When a private citizen breaks the law, the state's response is swift and overwhelming. With a flash of sirens and the full force of a police department, the government exercises its legal authority to arrest and detain the accused. The criminal justice system is built entirely around this dynamic. The government acts as the prosecutor, bringing charges against an individual. The end result is punitive, resulting in fines, probation, or a loss of liberty through jail time. But a severe imbalance exists in this design. Consider what happens when the roles are reversed, when an officer uses excessive force, or a local official violates a citizen's constitutional rights. An individual citizen cannot file criminal charges against a corrupt official. You can report a crime, but only the government, represented by a state prosecutor, holds the authority to actually file criminal charges in court. If a prosecutor declines to press charges against a fellow government employee, the victim is left with a severe legal deficit. The entities empowered to protect the public become effectively shielded from criminal consequence. To navigate around this roadblock, victims must step into a completely different arena, civil law. Here, disputes are resolved between private parties. The objective is no longer to put someone in a prison cell, but to compensate the injured party for their damage. Because civil lawsuits deal with money rather than a person's physical freedom, the math required to win changes. In a criminal trial, the government must prove guilt beyond a reasonable doubt. Civil court requires only a preponderance of the evidence. You just have to prove that your claim is more than 50% likely to be true. The primary legal tool citizens use to seek these damages for constitutional violations is a federal statute known as Title 42 of the United States Code, Section 1983. To use Section 1983, a plaintiff must prove the offender acted under color of law. This means the lawsuit only applies if the official abused the specific authority granted to them by their government position, like a police officer weaponizing their badge during an unlawful arrest. A Section 1983 lawsuit will not send an abusive official to prison. Instead, it creates leverage by imposing severe financial liability, forcing the government to pay out of pocket for the civil rights they violated. Filing the lawsuit is only the first step. The state insulates itself with layers of overlapping legal defenses. Aiming your lawsuit at the wrong entity guarantees an immediate dismissal. This text highlights a major trap. Under the 11th Amendment, states and state agencies are immune from being sued for monetary damages in federal court. However, municipalities, like cities and counties, are considered persons under Section 1983 and lack this protection. Even when targeting local government, plaintiffs often make a fatal procedural error by naming the local police department or sheriff's office as the defendant. These departments are legally classified as non-suable entities. To succeed, the lawsuit must target the municipality itself, the city or the county that oversees the department. Suing the city requires clearing another high hurdle. A municipality cannot be forced to pay simply because they employed a bad actor. The plaintiff must prove the officer's actions were the direct result of a broader, officially sanctioned municipal policy or a deeply ingrained local custom. The law offers a path to accountability, but it is highly specific. Targeting an immune state agency or a non-suable department will cause the case to collapse before the evidence is even heard. The most common, yet most difficult way to prove a city is responsible for an officer's actions is by arguing deliberate indifference. This typically involves claiming the city completely failed to train its officers on how to respect constitutional rights. This law review excerpt notes establishing negligence is exceptionally difficult. Estimates suggest barely 1% of these claims succeed. A plaintiff cannot point to generally poor training. They must prove a highly specific deficiency in the city's training program was directly linked to their violation. Standards for deliberate indifference require mountains of precise evidence and immense endurance from the injured party. The civil justice system is deliberately constructed with this high level of friction, serving as a powerful filter to protect local government budgets from endless payouts. Despite the procedural traps and demanding burdens of proof, this legal framework remains one of the few ways to challenge state authority. It bypasses the protection of internal police reviews and forces government actions out into the light of a public courtroom, overseen by a judge and jury. The legal apparatus relies heavily on the public remaining unaware of the exact rules required to navigate it. But when everyday citizens understand how to accurately target their claims and meet the evidentiary demands, they finally gain the leverage to extract real financial consequences from the powerful systems meant to serve them.